Hello, everyone. It is wonderful to see this great house on such an important anniversary, the 150th anniversary of the 14th Amendment to the U.S. Constitution. I am Jeffrey Rosen, the president of this wonderful institution, which is, Mr. Sloan, the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And that beautiful nonpartisan mandate, which has inspired so many of you to recite it in your sleep, has never been more beautifully served than by the initiative that we're celebrating tonight. The post-Civil War amendments to the U.S. Constitution, the 13th, 14th, and 15th Amendments, turn 150 over the next 5 years. And this year is the 150th anniversary of the proposal of the 14th Amendment. And when I teach constitutional laws, all of you who study it as citizens know, so many of the questions that transfix our national life today come back to the interpretation of the 14th Amendment. The 14th Amendment says, I can't do the whole thing by heart, but this is the gist of it. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And then the crucial words, no state shall make or enforce any law which shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. And that transforms the Constitution. Jefferson promises in the Declaration that all men are created equal. The original Constitution with the stain of slavery violates that promise. Madison wants the original Constitution to forbid the states as well as the federal government from abridging these basic rights, and it takes the bloodiest war in American history, the Civil War, Lincoln's promise at Gettysburg, and finally the 13th, 14th, and 15th Amendment to make that a reality. So there couldn't be a more important second founding to commemorate, and we're commemorating it with the help of the National Endowment from the Humanities. The National Endowment has this wonderful initiative which is aimed at fostering meaningful dialogue in communities across the country. The NEH believes that the perspectives of the humanities, history, literature, and philosophy can be brought to bear on our current challenges and help us understand the context and complexity of these issues. And we're so thrilled that they're supporting this beautiful second founding initiative all year and into the future. We have two blockbuster panels. And the first one is moderated by our superb partner in this second founding initiative, the Constitutional Accountability Center, led by the visionary and wonderful Elizabeth Wydra. So the Constitutional Accountability Center is a group that is dedicated to the proposition that constitutional text and history, when studied carefully, can lead to progressive as well as conservative results. And it's part of a movement in the country, in the scholarly community that is making these arguments. And Elizabeth, under her leadership, the organization is just being taken to new heights. She was previously chief counsel of the Constitutional Accountability Center. She came from private practice in San Francisco. She represents the Constitutional Accountability Center before the Supreme Court. You've seen her on TV and in print, and she is just doing a superb job. It's important for Elizabeth and me to let you know that this second founding initiative was the brainchild of the late Doug Kendall, the former head of the Constitutional Accountability Center, this great visionary leader who we miss so much, who passed away last year, thought that it was important for Americans of different perspectives to celebrate the Reconstruction Amendments, and we're all here because of his vision. So Elizabeth is moderating, and you have this incredible panel of scholars to discuss the history and contemporary meaning of the 14th Amendment. Dr. Alan Guelzo is Director of Civil War Studies and the Henry R. Luce Professor of the Civil War Era at Gettysburg College in Gettysburg, Pennsylvania. He's one of the most important scholars of Reconstruction in America, author of, most recently, Redeeming the Great Emancipator, also of Abraham Lincoln, Redeemer President, Lincoln's Emancipation Proclamation, the End of Slavery in America. He's been here, and everyone who has heard him knows how riveting and learned he is. We have two other return champions. Gerard Magliocca is Samuel R. Rosen, excellent name, although no relation, professor at the Indiana University Robert H. McKinney School of Law. He's the author of the definitive biography of John Bingham. And as you'll learn, John Bingham is the James Madison of Reconstruction. He's the representative who drafts the 14th Amendment, forgotten for almost a century, and Gerard, in his wonderful book, resurrects this great American founder. And finally, the superb Theodore Shaw is Julius L. Chambers, Distinguished Professor of Law and Director of the Center for Civil Rights at the University of North Carolina School of Law at Chapel Hill. He was the 5th Director, Counsel, and President of the NAACP Legal Defense and Education Fund. Among his many achievements, he's contributed the Equal Protection Clause explainer on the interactive Constitution, which you can see at constitutioncenter.org, and we are so honored to have him. Ladies and gentlemen, please join me in welcoming Elizabeth Wydra, Alan Guelzo, Gerard Magliocca, and Ted Shaw. Thank you. Good to see you. Gerard. Thank you.
Thank you so much, Jeff, for that wonderful introduction, and thanks to all of you for being with us tonight. It is really lovely to be here, to be celebrating this second founding, not just because I, like you, I assume since you're here, share a love of the Constitution, but also because it is the legacy that my former boss, mentor, and friend really started. Doug Kendall's vision for the second founding commemoration is wonderfully realized tonight and here with all of you, and with our wonderful partnership with the National Constitution Center. So thank you again, Jeff, for having us all here tonight. We at the Constitutional Accountability Center love the whole Constitution, but I confess I have a special place in my heart for the 14th Amendment. And I am not the only one. In 1866, Schuyler Colfax, Speaker of the House of Representatives, called Section 1 of the 14th Amendment, which you heard Jeff read some words of just a moment ago. He called Section 1 the gem of the Constitution. The gem of the Constitution, because it places immutably and forever the Declaration of Independence in the Constitution. Before the Reconstruction Amendments, as Jeff alluded to in his opening remarks, it is difficult to say that our Constitution lived up to the Declaration of Independence, our founding manifesto of freedom and liberty and equality. Because how could our national charter live up to that when you had a constitution that sanctioned the institution of slavery? Now, the 13th Amendment did a lot of the work of pulling our nation's charter back into line with the ideals of the Declaration of Independence by abolishing the institution of slavery. But the 13th Amendment really begged the question, what does it mean to be free under America's Constitution? And the 14th Amendment goes a long way to answering that question. It says in Section 1, equal citizenship at birth, whether your parents were rich or poor, saint or sinner, whether they came over on the Mayflower or were brought in bondage on a slave ship. Equal citizenship at birth. It guarantees due process of law for your life, liberty, or property. I guess we sort of did away with the pursuit of happiness in the Declaration. Property is a little more, I guess, concrete. But all those things together lead to the pursuit of happiness, one would argue. And then it guaranteed importantly, and importantly in today's debates, equal protection under the law for all persons. All persons. That includes persons of any color, persons of any creed, citizen or stranger. So these words are echoes of the Declaration of Independence. But while we know very much about the author of the Declaration of Independence, we don't talk as much about John Bingham, who was the architect of the 14th Amendment. Now, he hasn't quite gotten the Lin-Manuel Miranda Hamilton musical treatment yet, although I'm sure there's a good case for that. But there is a wonderful book written about him by our wonderful panelist here tonight, Professor Magliocca. So I wanted to turn it to you first and ask you to tell us a little bit about John Bingham, the Ohio congressman, who, as you talk about, is the architect of the 14th Amendment.
Well, thanks for coming. I'm delighted to be here. John Bingham was an anti-slavery congressman from Ohio who served both before the Civil War, during, and after, and was one of the leaders of the anti-slavery movement in the Republican Party. He became particularly noteworthy as one of the prosecutors of the assassins of President Lincoln. And after that was done and Congress was taking up the question of what to do after the Civil War with the ex-Confederate states, he became the leading advocate for a constitutional solution that involved guaranteeing fundamental rights to all Americans in the language that Jeff quoted. He fought extremely hard for that language in the committee of Congress that had to take up these questions. He had it taken out many times and put it back in and kept insisting that it had to be in there, and that really the 14th Amendment was something that was vital for the nation's future. He was a serious man. He was a sort of perseverant, one might say stubborn man, and it's sort of an unheralded role that he played, in part because he died in obscurity, kind of broke. And it's really only in recent years, especially after the Civil Rights Movement in the 1960s, that we've started to look differently at the men who led Reconstruction and played a role in putting the 14th Amendment together. And so he really did play this sort of pivotal role in sort of shaping what America was going to look like after the Civil War, and the 14th Amendment was a big part of that.
So I won't have you do a freestyle hip hop rap about John Bingham, but if you're so moved later.
If anyone wants to write one, I'm happy to help out.
Yeah, you can put it on a little card that they're going to ask. In drafting the 14th Amendment, one of the things that I find really interesting is that there was this consideration of how broadly or how narrowly to write it. There were proposals in the drafting committee to limit the 14th Amendment's focus to specifically discrimination on the basis of race. Obviously, we are in the context of the post-Civil War era, but those more specific proposals were rejected. And Professor Shaw, you wrote in your explainer for the Equal Protection Clause for the National Constitution Center about this duality, the idea that you have a sweepingly worded 14th Amendment that does cover equal protection of the laws for all persons, but yet is clearly, in its original purpose and its intention, focused on discrimination on the basis of race. Can you speak a little bit more about that duality and how you think it shapes the 14th Amendment?
Sure. This issue of the duality of the 14th Amendment is one that has echoed down through the years, and is very much a part of the jurisprudential debate that continues even in 2016. So the duality, as we know, goes like this. You've just touched on it. The purpose, unquestionably the purpose of the 14th Amendment was to put those who had just come out of slavery on equal footing with white citizens. Now I say that, but we have to drop a quick footnote. Actually, it's worth a whole lot more than a footnote. The 14th Amendment didn't do a whole lot for women. It was really about black men more than anything else, although it did give citizenship to anyone born in the United States. But with respect to equality, the 14th Amendment didn't do a whole lot of work that had to wait until the 19th Amendment with respect to women. The 14th Amendment clearly, though, was about African Americans. And if you look at the first case that interpreted or applied the 14th Amendment, of course, the slaughterhouse cases, which had nothing on its face to do with race, in the opinion, you find the statement that on the part of the justice who wrote the opinion, that this is, I doubt that this amendment will ever be about anything more than those who have come out of slavery. How wrong he was. And the language of the 14th Amendment, of course, is clearly not limited to African Americans or to race. It talks about equal protection of the laws. That applies to everybody. We could get into a long and deep conversation about what it took to rehabilitate the 14th Amendment, because it was almost dead on arrival in terms of its effectiveness as a vehicle for protecting African Americans from racial discrimination. And the amendment itself was used, as we know, for a long period, most notably in the Lochner era, to protect business, to protect other interests, before the 14th Amendment had life breathed back into it in 1954, actually beginning in the 1940s. I often talk about the duality of the 14th Amendment being perhaps as evident as anywhere else in the Supreme Court's 1978 decision in Bakke, in which the Supreme Court basically threw the constitutional remedial rationale, as I put it, under the bus, to use colloquial language. Ever since then, it's been very difficult to interpret the 14th Amendment in a way that really gives it the kind of vitality that many people think it ought to be given. One more thing on this. Mm-hmm. I think it's very important to read the 14th Amendment in conjunction with the 13th Amendment. Not everybody sees that. Not everybody agrees with that. But I would make a case, and others have also talked about this, of kind of two 14th Amendments. The 14th Amendment that applies to everybody, and the 14th Amendment that was meant to apply to the special condition of African Americans, which has kind of the 13th Amendment inside of it, if that makes sense. But this is a duality that we continue to wrestle with in our jurisprudence, even down to the present, including in the Fisher case that's up in the Supreme Court this term, with respect to admissions to selective institutions of higher education.
Mm-hmm. And I certainly want to get to the current litigation disputes over the 14th Amendment, but I think there's something interesting that I want to keep focused on in what you said, with this reading it together with the 13th Amendment. Again, certainly the 13th Amendment is written broadly in that it abolishes slavery, but the idea of getting rid of the badges and incidents of slavery were, of course, more meaningful for African Americans in our country than for any other group of people. So you're exactly right that while you have a broadly worded amendment, just as with the 14th Amendment, the 13th Amendment clearly has that dual purpose and intention. And I think reading them together with the 14th Amendment with the 13th Amendment, the 13th Amendment is so often thought of as Lincoln's amendment. And Professor Guelzo, you are a scholar of Lincoln, an expert on Lincoln, and you've written about the Civil War and Reconstruction. And can you place for us the 14th Amendment in that broader context?
Well, first, I have to admit that as I sat here, I was inspired to write a hip-hop lyric.
Oh, good.
for John Bingham. And it goes like this. John Bingham hated slavery. He fought with verve and bravery. He wanted men of every hue to have what was to each man due. He wrote the 14th Amendment. He urged us to improvement. And we remember him today because he showed us all the way.
Bravo!
You want a copy of that?
I do, but right now is when you're supposed to drop the mic.
Yeah, exactly. I think our poor person who has to re-mic the other group might not be happy about it. Well, and you didn't even have to pay $4,000 a piece for a ticket to get that. You just got that right here. Good job.
Well, the 14th Amendment, along with the 13th and 15th, are often referred to as the Reconstruction Amendments. And I think that of the three of them, the 14th certainly is very, very critical. I don't want to say the most critical because you really have to begin with the 13th. The 13th has to get rid of slavery. The question then becomes, once you've got rid of slavery, what Lincoln called the king's cure for the evil, of slavery. Once you got the 13th Amendment in place, then what? All right, we've gotten rid of slavery, we've abolished slavery, now the slaves are free. What does free mean? And Reconstruction was going to be the time period in which that got hammered out. And it has to get hammered because there's no guidebook available for how to do a Reconstruction. There's no Reconstruction for Dummies you can get in the bookstore. So there's no handbook, there's no process. This is what you have to do, take this step, this step, this step. It's all a question of, well, what do we do now? And in a way, Reconstruction has to be seen from the perspective of the people on the ground as really one great big improv. Because they fix a problem and then another problem bursts out. All right, then we're going to fix that. Oh, but then we've got to fix this other. Right at the opening of the Congress that assembled immediately after the end of the Civil War in December of 1865, Thaddeus Stevens was on his feet right away. He wanted to talk about a civil rights bill because Stevens understood right away that 13th Amendment is great, but that's not far enough. We've got to look at equality of rights, not just an equality of free status. But how do you pass legislation like that when the Constitution really doesn't give you any handle for it? The Constitution doesn't talk about equal citizenship because the Constitution doesn't define citizenship. There are 4 references to citizenship in the Constitution, but they don't really define what it is. So, all right, now we've got to define what a citizen is, because the one person who did step forward before the Civil War to define what citizenship was Roger Taney in Dred Scott. It was as though Taney had said, well, you know, you people in the Congress, you people in the executive branch, you haven't managed to settle this question about slavery, so we on the court, we're going to do it. And we're going to do it through Dred Scott. And Dred Scott simply said, okay, we know what citizenship is, and black people can't be citizens. Are incapable of citizenship. It's what we would call, if I can be technical for a moment, the jus sanguinis. You know, law according to blood, law according to birth. You become a citizen because you're entitled to do that because of your parents, or your lineage, or your descent, or your ethnicity. How to get around that? That's the first challenge. And Thaddeus Stevens' first instinct was, well, let's pass a civil rights bill. Lyman Trumbull introduces a civil rights bill. John Bingham won't sign on to that because Bingham, it's not because he wasn't sympathetic, it's because Bingham recognizes, wait a minute, we're going to have to do something constitutional first. Because we can't talk about equal citizenship until we've defined citizenship. So that critical first section of the 14th Amendment is a way to answer the question posed by the 13th Amendment. If everyone's free, then what does it mean to be free? Free attaches to whom? All right, attaches to citizens. Right, what's a citizen? So the 14th Amendment reaches out to establish what citizenship is. Now, having done that, they will have to go on to the 15th Amendment, because after you've said that citizenship is a national phenomenon and it obeys the jus solis. In other words, if you're born in the United States, you're a citizen. It's not based on your race, it's not based on your ethnicity, it's not based on where your parents came from. It's based on the fact that you're born in the United States. That, of course, would include every slave. So anyone who had been a slave, who is now free, would also, by virtue of the fact of having been born in the United States, be a citizen. Of course, that then is going to yield to another question, and that is, great, now we know what a citizen looks like. What does a citizen do? Does citizenship include voting? Does it include other kinds of civil transactions? Marriage, does it include that? Constitution didn't say, 13th Amendment didn't say, 14th Amendment didn't say, so okay, let's move on to a 15th Amendment, which does in fact specify voting rights as being linked to citizenship. But it really becomes improv as one by one, the members of Congress have to come to grips with the questions that are raised. So you look at the amendments, and from our perspective, we look at them and say, well, sure, right, that's perfectly obvious. But it wasn't then. They had to work through and work in the face of a hostile president, Andrew Johnson. They had to work through this step by step. And if it sometimes seems very gradual and very torturous, it was because they didn't have any guidance. They were feeling their way legally and constitutionally. And it seems to me that actually makes the Reconstruction Amendments all the more remarkable.
Mm-hmm. Absolutely. And I you know, you, yeah, please.
Dred Scott left a dilemma after the Civil War, which was that Dred Scott had not been overruled. You know, it still was good law by good law. I don't mean right law, but I mean it was controlling law. And Dred Scott didn't only say that slaves could not be citizens. It said that black people could not be citizens. Negroes, the language at the time, could not be citizens, including those who were free. So something had to happen. And that was part of the dilemma. That's why you get right out the box the birthright citizenship clause that, and you all heard, we're here for nonpartisan reasons, but some folks in this country are saying we ought to abandon. Now, most people don't understand the real context in which that clause was created. The second thing that I wanted to emphasize was that the issue of the ballot voting rights, that was not a civil right at the time of the adoption of the 14th Amendment. So we think of the right to vote as being protected by the 14th Amendment today in addition to the 15th Amendment, and it is. But it wasn't that way then. Therefore, the necessity of the 15th Amendment to address the right to vote.
That's a preview of next year's celebration, is the 15th.
Well, I was going to say that one of the ironies about the controlling influence of Dred Scott is that when Tony writes Dred Scott, he really bases his conclusions about the rights of slaveholders to take slaves into the Western territories, he actually bases it on due process and privileges and immunities.
Yes.
So what the 14th Amendment does is in fact even more dramatic than just simply talking, all right, this is now going to be the ruling definition of citizenship. That's not the only part of Dred Scott that it breaks up. It takes head on everything that Dred Scott tried to deploy as a means for justifying slavery. And that included the way Tawny tried to use due process.
And consider the backdrop of the amendment. After the war ended, the southern states agreed to the abolition of slavery, but then immediately passed many laws that imposed all sorts of restrictions on the freed slaves, where they could go, how they could work, what they could and couldn't do, that were essentially just a replication of all of the slave codes that had existed prior to 1865. So people like Bingham and the other founders of Reconstruction looked at this and said, well, if this stands, then all of these men will have died in vain. What was the point of the war if we're going to simply recreate the Union with slavery abolished in name only, but with the freed slaves having all of these restrictions imposed upon them that basically make them little more than slaves? So there was kind of the specific evil that they were sort of concerned about and trying to target, though what they were trying to do went beyond that as well.
And you know what was the really sharp edge of that? Up until the 13th Amendment, it was still possible for slave states to claim, under virtue of the 3/5 clause, extra representation. Now, that we today look at and say wasn't a terrible thing, 3/5 of a person. Remember that the Constitution was actually limiting the Southerners by allowing them to count only 3/5 of their slaves toward their representation in Congress. Now, with slavery abolished, Southerners can come back into the Union. They could elect their old Confederate generals and Confederate officials to Congress, which they did. And they would be entitled to still more representatives because now the freed slaves would be counted as 5/5, despite the fact that those slaves had no say. Those ex-slaves had no say in voting. So suddenly, this means you end the Civil War, you put down this great rebellion, you end slavery, and the South comes back into Congress stronger than it was before and with the same people.
Which is why the 39th Congress, when the roll was called, passed over the Southern delegations and refused to seat them.
But I think that emphasizes John Bingham's wisdom in not just going with the Civil Rights Bill, but putting into the Constitution these protections, because with the increased power of the South, you had the possibility that a future Congress could come in and take away all of the gains that had been so hard won in that bloody Civil War. And obviously that worked out better for some of the guarantees in the 14th Amendment than others. Certainly with citizenship, constitutionalizing the conditions for citizenship made them not subject to the whims of the politics of the day, and those have remained in place, although, as Professor Shaw points out, there are and have been continuous threats to the birthright citizenship rule, although they thus far haven't gone anywhere. But as we know, the guarantees of liberty and equality were not an immediate reality for Black Americans in the South. And many of the Reconstruction legislation that was put in place in order to remedy the effects of slavery and racial discrimination, the Freedmen's Bureau, opportunities for educational and economic advancement, were thwarted through Reconstruction. Would someone like to speak about that? I know you've written a book on Civil War and Reconstruction, so I'm looking to you, Professor Guelzo. You don't have to do it in hip-hop rhyme.
Well, bear in mind, we've focused up to this point on only one point in the 14th Amendment, and that is its first section, which is pretty potent.
It's a pretty good one.
Right. But it actually does some remarkable things beyond that, which again speak to the anxiety that pervaded the first Congress after the Civil War, that somehow the South was going to come back bigger and badder than ever before. And one of those sections, of course, is the section about the public debt. Now, reading a section of an amendment about the public debt is about as interesting as watching the grass grow. But bear in mind, what it says in that section 4 of the 14th Amendment is, under no circumstances whatever will the United States ever assume responsibility for the Confederate war debt. Now, that's in there as an amendment to the Constitution. You might think, well, why an amendment to the Constitution? That seems like overkill. No, it's not. Because if those Southern representatives, now coming back, energized with that 5/5, if they came back, renewed their alliance with Northern Democrats as they had before the war, they could pass legislation in Congress saddling the entire country with paying the debt of the Confederate States of the United States, or Confederate States of America, and thereby saddle the entire country with having to pay the bill for the people who rose up in rebellion against it. How do you like that one? So that Section 4 is actually an extremely important one. Section 3 talks about disabling Confederate officers, high Confederate officers, from occupying positions of authority, being elected to Congress. Because, once again, what are you going to do? You're going to take people who have fought against the nation, people like Robert E. Lee, who resigned from the Army, repudiated de facto the oath he had taken as a United States Army officer, fought for 4 years, inflicted untold casualties, and at the end of the Civil War, you're then going to turn around and say, oh, well, why don't we nominate him for governor of Virginia? Now, you would look at that and say, that's incredible. What could they be thinking? People seriously proposed that. So the 14th Amendment also is addressing that, and this galaxy of questions that today, to us, don't seem to be all that pressing, because they never came to fruition. But for the Congress in 1865 to 66, were actually right on their doorstep as possibilities that could have completely upended all the results of the Civil War. I mean, imagine that. It's difficult to imagine it. It's horrible to imagine it, but it could have happened.
So the famous story, you've all probably heard it, being here in Philadelphia, when Benjamin Franklin leaves the Constitutional Convention, he's asked, "What have you given us, Dr. Franklin?" by a woman, and he says, "A republic, madam, if you can keep it." Well, in the case of the 14th Amendment, we had been given a form of creating racial justice if we could keep it, but we didn't. Or at least we didn't for a very long time, and of course are still working towards it. Now, when that happens, the question is that the fault of the designer of the system or the fault of those who came after? Right? And probably the answer is some of both. But it's easy to sort of think that maybe there was a flaw from the beginning in the way the 14th Amendment was set up. Or, on the other hand, maybe one thinks that it was set up perfectly well and the problem rested with other political developments that occurred afterwards. And so I think that at any moment you're capable of losing achievements that have been hard fought and hard won. And so that's something that I think is one of the harder questions to answer about the 14th Amendment, as to kind of why it took so long to kind of get it to a point where it really redeemed the promise that was made.
And I think that dovetails directly into several questions that we've gotten from the audience, which is that, how is it that despite the Equal Protection Clause and this great language that we have in the 14th Amendment that does protect equality and does protect against racial discrimination, that we then had the harsh, re-legalized discrimination of Jim Crow South for so long, until thankfully we had Section 5. We're talking about other sections of the 14th Amendment. We have Section 5 of the 14th Amendment that allows Congress to enforce the terms of the 14th Amendment, enforce those guarantees. And Professor Shaw, you litigated for many years with NAACP-LDF the legislation that was put in place by Congress to enforce the terms of the 14th Amendment and try to get rid of the vestiges of slavery as expressed through Jim Crow and laws in the South. Can you speak to that a little bit? How we finally overcame the thwarting of Reconstruction in the aftermath of the passage of the Reconstruction Amendments?
Well, slavery wasn't cold in its grave before the Supreme Court said in the civil rights cases, a challenge to a civil rights statute, very much like the civil rights statutes of the 1960s, like the Civil Rights Act of 1964, from various jurisdictions, that law was struck down. Mm-hmm. In fact, the language of the civil rights cases, in part, talked about how there comes a time when a people recently freed from slavery, the vestiges of slavery, have to stand up on their own 2 feet and cease to be, quote, the special favorites of the laws, end quote. And in case that escaped anybody, it was black people who were accused of being trying to be the special favorites of the laws. It was an argument that we would describe today as what's called reverse discrimination. Slavery not cold in its grave when the civil rights cases were decided in 1883. But the real turning point, as we know, though any of us who are students of history, was the contested election in 1876, Hayes-Tilden, which led to the withdrawal of Southern troops from the South, a compromise that led to President Hayes taking office as opposed to Samuel Tilden. And once those troops were out, if it wasn't clear already, and in many places it was, that the black codes were in full force and black folks weren't going to be protected, it was clear after that. And the Supreme Court began to, there were a few more opinions we could talk about, decisions that were important involving jury service and other issues, but Supreme Court began to get out of the way, and that was that culminated with the infamous decision in Plessy versus Ferguson in 1896, which began a long period of time in which the 14th Amendment meant almost nothing for African Americans in terms of protection from racial discrimination. That was largely true even while the 14th Amendment was used, as I indicated before, and as we know, to protect big business, to protect employers, the right to work, which was actually a right that presumed that employers and employees had equal bargaining power, the Lochner era. And it wasn't until the Supreme Court's decision after the end of that Lochner era, West Coast Parish Hotel case, but really the Supreme Court's decision in U.S. versus Caroline Products, the most famous footnote in Supreme Court history that began to set up the paradigm for enforcing the 14th Amendment with tiered scrutiny. The racial discrimination receiving the highest form of scrutiny, being presumptively invalid, that we began to see some life breathed into the 14th Amendment. Mm-hmm. There's another story here that I just want to allude to. Most Americans have never heard of one of the lawyers who has had as much impact as any other lawyer in American history on our country, Charles Houston, an African-American lawyer who really was the individual who not only trained Thurgood Marshall, mentored him, and made Howard Law School into a factory for civil rights lawyers, but also began to set us on the road to Brown versus Board of Education. That's a key part of this story and the revival of life into the 14th Amendment through the creation of the NAACP Legal Defense Fund.
Mm-hmm, mm-hmm. Absolutely, and speaking of those great lawyers, we saw with the Brown versus Board of Education decision the rolling back of the Supreme Court's grave mistake in Plessy, but it was really not that long after, as you alluded to in your earlier remarks, in Bakke in the 70s, that the court arguably cut back on the idea that it's necessary to remedy the systemic effects of state-sanctioned intergenerational racial discrimination. And you mentioned the Fisher versus Texas case, which brings us to the present day in our 14th Amendment discussion. The Fisher case is up at the Supreme Court this term. It is yet to be decided, but it has to do with race-conscious admissions programs at the University of Texas. And I think it's a really interesting place for us to have this conversation because it brings together a lot of different views about the continuing importance of the 14th Amendment, what the Equal Protection Clause means. I know you've spoken about the difference between the diversity rationale, which is that you want to have a racially diverse student body, that's an important goal, as opposed to the remedial rationale, which is that it's important to provide access to educational opportunities because of this systemic state-sanctioned racial discrimination that has been part of our history. And I was wondering how you see the Supreme Court right now in this moment. We've had the Roberts Court. I don't know if you all are familiar with Chief Justice Roberts' famous, very age of Obama kind of statement that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race, which he used in a case about schools voluntarily desegregating. But there was a seeming to me shift in the court last term with a surprise victory in a Fair Housing Act case that seemed to be very cognizant of the lingering effects of racial discrimination in the United States. And I just wondered what your thoughts were on where we are with the court. You talked about the error of Plessy and then the change in the court, and we're sort of again at this turning point with the Supreme Court. And I should say that Professor Shaw was a part of the administration when he taught at University of Michigan that came up with the admissions policy that was challenged in the Supreme Court in the 2003 cases, and part of the legal team that defended that in the Supreme Court.
Well, I wish we could have a full discussion of these issues. The thing that I would stress is that Bakke in 1978, I always say that we have to put all of this into a historical perspective. We as Americans are selectively very ahistorical. We have this wonderful place we have across the mall here, Constitution Hall, and we're very proud of all of that, as the country ought to be. But, I often quote a line from the theme song to, I date myself when I say this, one of my favorite love stories. I'm a sap for love stories, and The Way We Were. And there's that line, what's too painful to remember, we simply choose to forget. And that's the way we are with respect to issues of race. And so the reason I think historical context is so important is because Bakke's decided in 1978, really about 8 years after I think we can say that the era of Jim Crow finally was ended. And Bakke was preceded by another case in 1974 that really raised the same kinds of issues. Bakke was medical school at the University of California. The DeFunis case was law school, University of Washington. The court ducked DeFunis because he had been provisionally admitted pending the outcome of the case, and by the time they were going to decide it, he was about to graduate, it was moot. The point I'm really trying to underscore is to get us to think about time. We talk about really 350 years, and then you get a mere 8 years, and the Supreme Court effectively throwing the remedial rationale and Bakke under the bus. Institutions can't do anything to remedy our inequality on lines of race unless they themselves were either found to have discriminated or they fell on their swords. But they can't cure what's called, quote, societal discrimination, end quote. That's discrimination for which no one's responsible and there is no remedy, and we wring our hands about it, we wash our hands of it. And then the court said that the 14th Amendment didn't mean anything special for African Americans. It didn't have any special significance for African Americans, and you judge attempts to try to include people in opportunity by the same standard that you judge attempts to subordinate people based upon notions of superiority and inferiority. That, to me, was intellectually dishonest. But that's what the court did in Bakke. And what it did was come up with not the court, but rather Justice Powell, this diversity rationale. I was at the Supreme Court in the courtroom when it was decided, and I left the courtroom devastated because I was very clear that for African Americans at that moment, Bakke was a loss. The diversity rationale, I didn't know what it was going to mean and what it would hold. Turns out that it held up quite a bit. But it really also turned African Americans into bystanders in these contests in the court. The subsequent cases are cases in which white people sue white institutions that are trying to diversify, and black folks have no voice, even though they're affected the most. Because the 14th Amendment rationale, the remedial rationale, was dead. And it was the First Amendment rationale, academic freedom, that carried diversity. I can go on and on about this, obviously, but I probably quite arbitrarily should stop there, except to say that this discourse continues today in our jurisprudence. And I think the 14th Amendment is a wonderful, wonderful instrument. It's important. But I also think it's been interpreted in a very disabling manner and often dishonest, intellectually dishonest manner. So
It certainly brings home the importance of understanding the history of the 14th Amendment. And, I think that talking about the way we were, I think this is a great question that requires us to get ourselves back into the headspace of the folks who were in the Reconstruction Congress. The question is, given the controversial language of the 14th Amendment, how did they ever get it ratified? That's a good question. John Bingham had dirt on everyone. He managed to.
Well,
They kept the Republicans out. I'm sorry, the Democrats out.
Through coercion. I mean, partly, that is excluding the Southerners from Congress until the individual Southern states ratified the amendment. It was a condition that they had to meet to come back into Congress. There was also the fact that the Union Army was in place in the South to sort of persuade people to go ahead and ratify. Now, not in the way that you might see in certain countries where people are being marched at gunpoint off to the ballot box to vote the right way. But, I mean, it was a fact of life that the Union Army was there and that there wouldn't be statehood for these southern states if they refused to ratify. Now, having said that, I should also add that it's not as if all northern states approved or all northern representatives approved of the language. There were northern Democrats. There were some states that even tried to repeal their previous ratifications of the 14th Amendment. And it was a close-run thing to say that finally it got done because, at some point people lose patience with political fights in Washington, right? I mean, we sort of see that from time to time. And so it's difficult to maintain extraordinary measures for a really long time. They did it for just long enough, or gained public support to do it for just long enough to get it ratified, but only barely. And in fact, you might say that what happened afterwards was weaker because after the amendment was ratified, the Southerners were allowed to come back in. And of course, they weren't interested in anything else that was going to be done to further the purposes of the amendment. So a lot less could be done after that than could be done when they weren't there. So part of the answer was extraordinary things had to be done in order to get it ratified, which just shows you how hard it is sometimes to ratify constitutional amendments.
Professor Guelzo, you get the last word. We're running out of time.
One of the difficulties about determining the impact of ratification is that the ratification debates on the 14th Amendment are surprisingly spare. One of the curiosities is that unlike the ratification debates over the ratification of the Constitution, where there's a tremendous volume of literature, the 14th Amendment seems to have gone past the state legislatures with surprising lack of commentary. Partly that was because by 1867, Congress had put into place in the former Confederate states a whole new governance regime under the Reconstruction Acts. So that curtailed a lot of resistance to the amendment. But it is even peculiar that in the northern states there was comparatively little in the way of commentary and debate. That poses a difficulty for us, because then when we go back and ask ourselves, well, what did John Bingham intend? What was the 14th Amendment supposed to do? Then it becomes very, very difficult, because we just don't have a lot in the way of evidence on the ground. I think that the 14th Amendment suffers from a history that is ambiguous. And part of the ambiguity is the fault of John Bingham, because Bingham himself gave ambiguous readings on what he thought the 14th Amendment had actually done. Was the 14th Amendment simply an attempt to bring the first 8 amendments to the Constitution into federal application in the states? Well, that in some contexts is what was in view, and that's a very limited view of the 14th Amendment. Or does the 14th Amendment actually incorporate federal authority to reach into and talk about voting rights, admissions, social equality of various sorts? The evidence on that is really difficult to determine. The commentators on this, even to this day, are severely divided over whether the 14th Amendment was ever intended to incorporate federal authority to the point where it could speak to situations in the state or in private contexts. And I don't think we've gotten through with that debate yet. So I expect that the 14th Amendment, as much as it is a product of history, is not going to remain an artifact of history, but we're going to continue to debate what the role of the 14th Amendment is. And there will be court decisions one way, there will be court decisions another. Slaughterhouse cases, civil rights cases, Crookshank, these were decisions that faced in one way in interpreting the 14th Amendment. Then you come to Adamson versus California in 1947. There you have Justice Black really laying down the outlines of an incorporation doctrine. But it's going to keep on varying back and forth, and that is largely because of the ambiguities that are built into the 14th Amendment right at its very birth.
Well, I think that the sweeping language of the 14th Amendment will continue to provide us with many opportunities for conversation, whether it is with the Fisher case in the Supreme Court, the marriage equality case from last term, applying the 14th Amendment, to the case that we didn't get to talk about, but is coming up in the out of North Carolina, HB2, about transgender access and in North Carolina. So there are many opportunities to think about the history and legacy of the 14th Amendment. And I look forward to our next panel. Having all the judges here certainly kept us on our best behavior. So I look forward to their conversation. But first, please join me in thanking our wonderful panelists. Thank you for your thoughts.
Program's not done.
So shall I?
Yeah.
Ladies and gentlemen, I am here to vamp for about 5 minutes or 4 minutes as our judges prepare for the next panel. What a great constitutional education you just heard. Elizabeth just did a superb job in eliciting our great panelists to summarize and elucidate all 4 sections of the 14th Amendment. So class, should we review some of what we just learned before the judges came in? Okay, here's some of the stuff that we learned together. The first clause of the 14th Amendment talked about birthright citizenship and said that in America, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That repudiates the Dred Scott decision, which said that African Americans could not be citizens and have no rights, which whites were bound to respect, and define citizenship based on birth rather than blood. Then you have that clause called the Privileges or Immunities Clause, and it said that there are basic civil rights, not political rights like voting, but civil rights that are uniform from state to state. Why isn't voting a civil right that's included in the 14th Amendment? Because if I live in Pennsylvania and I go to Delaware, I can't vote in Delaware elections or serve on Delaware juries, but I can make contracts that can be enforced in Delaware. So these basic civil rights, like the right to contract, to property, these economic liberties, are uniform from state to state, but voting is not. And then there are those other 2 clauses which talk about the right not to be deprived of life, liberty, or property without due process, and the right of equal protection of the law. And we heard a moment ago that some of these basic privileges or immunities or civil rights included the rights that were in the first 8 amendments to the Bill of Rights, prohibiting the states as well as the federal government from infringing those fundamental rights. But Professor Guelzo at the end said there's a disagreement among scholars today about how much of the Bill of Rights was incorporated against the states and what the basic privileges or immunities of citizenship are. And we're about to hear that there's a dispute about whether the economic liberties that the framers considered protected should be treated at the same level as personal and civil liberties. And then we talked about Section 2 of the 14th Amendment and learned, wasn't that interesting? They're so afraid of the southern states unfairly taking advantage of their African-American citizens who are not granted the right to vote and swamping Congress, that apportionment in Congress is reduced for southern states that don't grant African-Americans the right to vote, but women are thrown under the bus, and the word male is inserted into the Constitution for the first time, the word of caste, C-A-S-T-E, saying, of course you don't have to grant women the right to vote, but if you don't grant it to African-American males, then your apportionment will be reduced. And then finally, we learned about the disabilities about Southern military leaders from joining Congress in Section 3. And finally, Section 4, which is back in the news just the other day when Mr. Trump said that he might reconsider the financing of the public debt. And some commentators suggest that that might violate the part of the 14th Amendment, Section 4, that says that the validity of the public debt of the US shall not be questioned. So, wow, that was just an extraordinary constitutional education and also effective 4-minute vamping on my part, because I've just gotten the thumbs up from Nicandro to introduce our next panel.